Start. In writ petition number 28691 of 2011, Dinesh Kumar Garg and others versus State of UP and others, the petitioner's case is that plot number 407M, khata number 111 was purchased by the petitioners by sale deed dated 7.4.2004. There is abadi of the petitioners which is being used for residential purpose, and in Khasra 1412 Fasli abadi is mentioned. It is stated in the writ petition that objections were filed by the petitioners vide letter dated 25.2.2010 to the Chief Executive Officer for exempting the petitioner's land from acquisition. Information was also obtained under the Right to Information Act 2005 and by letter dated 6.10.2010. The petitioners have been informed to the effect that out of 1.178 hectares of land of plot number 407, only 0.778 has been proposed for acquisition and rest has already been left for abadi. Reliance has also been placed on interim orders passed in writ petition number 30914 of 2009, Mandan Pal versus State of UP and others dated 16.7.2009, by which order direction was issued for maintaining status quo. Challenge to the notification of sections 17 in bracket 1 and 17 in bracket 4 has also been raised, stating that there is no justification for dispensing with the inquiry under section 5 capital A para. In writ petition number 32236 of 2011, Satpal versus State of UP and others, almost identical pleadings have been made as has been made in the main writ petition. Learned counsel for the petitioner submits that petitioner number 15 and 16 have not accepted even the additional compensation offered by the authority after the order of this court dated 26.7.2008. In writ petition number 39584 of 2011, Khem Chand versus State of UP, similar pleadings have been made as made in the main writ petition. It has been additionally stated that petitioners number 1 to 6 have not accepted additional compensation. In writ petition number 39584 of 2011, an intervention application has also been filed by Noida Extension Flat Buyers Welfare Association, in which application it has been stated that writ petition filed by the petitioner is not maintainable in view of the delay and laches. The original tenure holders are not entitled for restitution of possession. It was pleaded that flat buyers who are members of association having faith and belief regarding the marketable title in the land of the builders have booked flats after taking due care, and any order quashing the notification shall take away the rights of the members of the association, causing loss to them. It is pleaded that there is acute need of residential units in NCR. Para. The writ petitions in group 2 are the writ petitions of village Sakipur. Writ petition number 47157 of 2011, Rajendra Singh and others versus State of UP and others relating to village Sakipur has been filed challenging the notifications dated 31.12.2004. issued under section 4 proposing to acquire 311.3140 acres of land of village Sakipur. Declaration under section 6 was issued wide notification dated 5.9.2005. Similar pleadings have been made in the writ petition challenging the notifications. The petitioners have pleaded that petitioners, being law-abiding citizens, were under impression that the state government has acquired their land for the public purpose. Hence, they did not come earlier to challenge the notifications. However, later, petitioners came to know that the very purpose of acquiring the land, namely planned industrial development, has now been changed by the respondents by carving plots, and the land has now been transferred to private builders for the purpose of commercial complexes and residential under the group housing scheme. The petitioners have annexed one of the lease granted by Noida Authority to one MI Builders Private Limited, wide lease dated 28.3.2007. It has also been pleaded that the entire acquisition proceedings have lapsed since the award has not yet been declared. Reliance has been placed on the judgment of the Apex Court in Greater Noida Industrial Development Authority versus Devendra Kumar and others, Supra, Para. It has been pleaded that under the impression that land is needed for public purpose, namely planned industrial development by the authority, the petitioners accepted the acquisition for the said public purpose, but in view of the change of land use, the entire acquisition proceedings deserve to be quashed. Reference to writ petition number 42631 of 2011, Ma'am Chand versus State of UP, has also been made, by which writ petition parties were directed to maintenance status quo by interim order dated 20.8.2009. It is pleaded that without application of mind, section 17 in bracket 1 and 17 in bracket 4 was invoked by dispensing the inquiry. Counter affidavit has been filed by the state government stating that petition has been filed with great delay and is highly barred by time, full stop.